Next case is cause number 322186, case of style of State of Texas versus Rosendo De Jesus Gonzalez. Mr. Gonzalez is appearing via Zoom. Mr. Gonzalez, is that your full name?
Yes, Your Honor.
Okay. Mr. Gonzalez, you're here represented by your attorney, Mr. Dustin Galmore. Mr. Galmore, what's your announcement in Mr. Gonzalez's case?
Ready.
Okay. And state?
Your Honor,
This is the one with the discovery.
right. Your Honor, it was my understanding that defense counsel took issue. He wanted a report on an intoxilizer. He filed a motion for a report on an intoxilizer.
I think this is a standard discovery
Yeah.
order. Yeah, it's been ordered. I signed it back in January 10th of, is that 20?
2020.
Wow.
Yeah.
Yeah, January 10th of 2020. You never got it?
No. So I had a conversation with him last week. Obviously, Judge, this is a new case for him through no fault of his own. It was just never been provided, and it's not even necessarily in the works. I don't know how long it would take, but my position on it is that it's been a long time.
Yeah, I mean, it was signed way back. Yeah.
It's been a long time, and I mean, again, it's not his fault, but what I would ask the court to do, out of the defense's perspective, we should proceed forward without the text, because
Oh, I don't, well,
they've not provided the discovery for the text.
you have some authority on that?
Well, I mean, produce it.
I understand, but I mean, do you have any authority on that to say that the court should allow them not to produce? I mean, we've had several prosecutors on this case. I mean, I don't know what the
I believe, was it Shaylin was the one that we're going to deal with that issue, but I mean, but certainly, Judge, there's lots of case law on the position that the court is in control of.
I mean, you could give me a brief on that. State could give me a brief on it too. But
Yeah, I think any discovery insufficiencies or deficiencies will be cured with a small restate of this case being placed on the next trial docket, and we get this report out to Mr. Galmore ASAP. I'm going to make it my priority, and I think any deficiencies in discovery will be cured with just a very short reset.
okay, give us the reset date.
October 17th.
That's that good for you? Okay.
I would just ask of this issue today, and if there was obviously any problem producing those records, but by the next court date, that it's an unending issue.
Yeah, we need to have a hearing on it. Yeah. Okay, so we're gonna reset it for trial October 17th. Blood discovery. Okay. Okay. You can get your reset. Mr. Gonzalez, stay in contact with your attorney. Your case has been reset for trial October 17, 2022, which is a month from today. Well, almost close to a month from today. A little over. Okay, so you'll be free to go.
Okay.
You have a blessed day.
Okay, thank you, Your Honor. Likewise.
All right, thank you. So,
And Judge, there was one thing I would like to just say real quick. I meant to say it earlier, and I don't know why it slipped my mind, but I've got, I guess, number 2.
you actually, you number 2 now.
I'm number 2 and number 3
Right, and 4.
and 4.
Yeah. Number 4 was, Bruno.
But I thought she just bumped up since Rosendo is.
Let me
gone
see.
now.
Let me see, we have, number 1 is Turner.
Okay.
Oh, that's right. That's right.
Gonzalez is reset now,
Okay, number 2 is, and then Tatum goes to number
too.
2.
And Miss Bruno would be. number
And then
three.
Bruno is number 3. Okay, we have, Turner, number 1, Tatum, number 2. And then Bruno, number 3.
That's right.
And then number 4 will be Jansen Bailey's case, Steele. And that's it.
So I'll say this again tomorrow, Judge, but I just want everyone to be on the same page, and not wait till tomorrow. Miss Bruno, number 3, would like to be number 1. She lost her daycare that she owned because of the filing of this case and cannot reopen it until this case is over, presuming that she would be victorious. And so, you know, I'm just requesting, and I think she would like for me to request
Yeah,
tomorrow.
okay, but there's no motion for speedy trial that was filed, is that correct?
That's correct, but we're not making a legal argument the court should dismiss her
Yeah.
for lack of speedy trial. We're just simply respectfully asking the court to give her priority if possible. That's all.
Yeah, the priority right now is on the filing dates,
I understand.
how old the case is.
If it's not an inconvenience to the court, I
Yeah.
think she'd like to get her case over with.
Okay, well,
So I just,
okay. Okay,
I just wanted to say that out loud. Everybody was on the same page. So tomorrow, if I say, I don't want to surprise anyone, that she would like to get her case.
Yeah.
over. Challenge to how long it's taking to get to her case, obviously.
well, I mean,
COVID was a big,
COVID is, yeah, that, we still in COVID. I
that's
mean,
very true.
and plus we got monkeypox.
That's true too. That's why I'm not,
Right.
that's why I had filed a motion, but you know, it's just a respectful request.
Yeah, but I mean, right now, so we got cases that's going, but like we said, we got everybody, you know, with these cases, the priority is, now we don't have nobody in jail. And so we going down the list in terms of the older cases. And we've been able to move a lot of the cases off the trial docket. We just, that we had these ones that just left.
I also, at 1 o'clock have both the 252nd and the CDC trial dockets.
Okay,
And I'm ready on 5 trials over there, but at this.
well, they
point, I
had the
don't
same
know.
problem we got.
That's true, but I just don't know if one's gonna necessarily,
Oh, I know.
we'll know here.
All right,
See you tomorrow. Thank you.
all right,
Judge.
all right, you welcome. Come forward. This is cause number 331-270, case of style of state of Texas versus Mindy. Is that Shuge Yanez? Ms. Yanez, how are you doing? Now, Ms. Yanez, your case was reset for you to hire an attorney. Have you hired your attorney?
Then I got deported. We got arrested on the 8th, then got deported on the 15th. And then I had a bad.
Okay, Okay,
And then all the money that I was giving in, it had to go to the bill, for my son and stuff. So, and then my board, they changed me from this.
okay.
So I wasn't able to get them. I just barely finished it.
Now, let me ask you, see, or do you still want to see, try to hire an attorney? How much time do you think you need?
I think I have this one job coming, so I said probably never.
Okay, give us 60 days.
November 7th.
Okay, this case is gonna be reset November 7th of 2022 to give you an opportunity to hire your attorney of your choice. Okay, stand on the 4X. Once you get your reset, you'll be free to go and you have a blessed day. John Willis Bernard. Mr. Bernard, this is cause number 328902, case is style of state of Texas versus John Willis Bernard. Mr. Bernard, is that your full name? How are you doing, Mr. Bernard?
Good, tired. Okay, work this morning, but I'm all right.
All right. Mr. Bernard, you represented by you in your case by your attorney, Attorney Tom Burbank, who is appearing via Zoom. Mr. Burbank, how are you doing?
Doing fine, Judge.
Mr. Burbank, what is your announcement in Mr. Bernard's case?
He is on the mental health caseload, is he not, Judge?
Oh, yes. In view of that, pursuant to Article 1.24 of the Texas Code of Criminal Procedures, all proceedings and trials shall be public. However, pursuant to Lilly versus State, 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as interest in the security, preventing disclosure of non-public information, and ensuring that the defendant receive a fair trial. Mr. Burbank, are you questioning that this portion of this hearing or this proceeding be closed to the public pursuant to Lilly versus State to prevent the disclosure of non-public information on your client?
Yes, Your Honor.
Okay. The court finds that the party seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced to the defendant in that it will disclose non-public information. The closure is no broader than necessary to protect those interests. And the trial court have considered other reasonable alternatives to closing this proceeding. And the court make these findings and the findings are adequate to support a closure. At this time, this portion of the proceeding will be closed to the